evidence, right? They have the evidence that support the contract. They have your signature, presume you signature. They have it on the winning side under the Admiralty Maritime. They have it. So this is the jurisdiction. Now, this is not equity. You will not get a fair chance, fair trial, fair hearing, or anything like that. Why? Because this is a presumption. This is going to be a maritime lien, a presumed lien, a secret lien. All right? So they bring you into that jurisdiction for what? Hold on, whoever damn wrong is, hold on. You talking way out of context, to be honest with you. You know, I was trying to follow you, but I was trying to make a point here too at the same time. So just hold tight if you can. So the damn lashes is coming up. So just hold tight if you don't mind. I appreciate the love, Gucci. Oh, definitely. It's a maritime lien. It's a presumed lien, secret lien, a lien you can't see, which is stupid. It's a lien you can't see, but it's a presumption of it. Why? Because of their legal status. Why? Because they have it authenticated on a county record. They have it recorded on a county record. That is why, or recorded at the DMV or what have you. It's all presumption. But what will perfect that lien under that maritime jurisdiction is a judgment. It's a judgment. So they call it a judgment lien. So that will perfect that lien under that maritime jurisdiction. And because the judge had to use the maritime jurisdiction based on the nature of the complaint, the nature of the case, the legal status of the case, and the legal status of the pleading that match the legal status name on the contract, is why the opposing side will always win. Because we as people, I'm talking about living beings do not have anything prepared to shift the jurisdiction now. Now we have to be in a position. Somebody said I'm waiting for the finish line. Okay, now how about let's shift right quick? Are we gonna get to the finish line in 30 minutes? I don't think so. But let's shift right quick. Okay, so the question is, can we shift the position? Can we shift the direction? Can we shift the jurisdiction? Come on, somebody say shift. Come on, Kiki said shift. So remember, they invoked it under maritime jurisdiction, and they have everything on their side. Yeah, we can shift that dang old jurisdiction. They have everything in their favor. So now, because we are living being, and we the one that created all three branches of government pursuant to the Constitution, remember what dictates the jurisdiction. It is your pleading. It is how you write your answer. It is how you write your. It is how you show your evidence, what evidence you show, how you write your answer, and how you style your case. It's how you style your case. Remember, when they styled your case in the pleading, they styled the case, you as a defendant, presumably, under your all-cap name that matches that legal name on that application or the legal name on that contract. Okay, that gave them that jurisdiction. But now it's like the judge is going to be in a tug-of-war of the jurisdiction, because the judge got to look at one complaint, and the judge got to look at your complaint, and now the judge got to decide, by reading the arguments, okay, in the legal status that's on the pleading, all right now, which jurisdiction that I have to rule under. So it has to be a favorable outcome, right? So this challenging jurisdiction at this point, you can challenge their jurisdiction once you got all your ducks in a row. So how do we shift the position? If you want to know how, type in H. Type in H. How do we shift that position in our favor? Type in the H, come on. Good deal. I may say some things, but I'm not going to tell you to do anything, all right? So do not think I'm sitting here by saying, oh, she about to sell us something. No, I'm not. No. I got too much to do, too much on my plate. So listen, y'all ready to shift the jurisdiction? Remember, that you want your equity to arise under the Constitution. Now let's talk about equity. Let's go into equity. That's the jurisdiction you want to be under. Equity. Right? Equity is about what? Your properties. Equity is about your assets. This is what equity is about, your fairness, that you have possession of. You have possession of your house. You have possession of your car. You have possession of your money. You have possession of your rights. You have possession of all your assets. You have possession, tangibly. You can feel it. You can see it. You can touch it. You can hold it. How you doing, Albert? This is equity. Now let's talk contract. So now to switch that maritime into equity, you now have to have a legal status. What is your legal status? To indicate that this is going into an equity jurisdiction. What is your legal status? Damn wrong. I see why they call you damn wrong. I got you damn wrong. You kind of making a point there. I love it, life coach. Life coach hit it. Life coach, you hit it. Life coach hit it right there. Right there. So because you, life coach, said that, let's ride on what life coach just said. So you got to have that. So that means your legal status have to say your name and put trust at the end. No, I get him. No, I got him. He good. That's why I say I see his point. So you want to have your name or your trust name. It doesn't matter if it's your name. Whatever name is on there, you representing that trust though. Whatever that name is on there, it ends in trust, right? As if you even do it as a defendant, it's still that name have to end in trust. Whatever that trust name is, it ends in trust. So first thing you want to do is that legal status, right? You want to change that legal status from that all cap name that they're using on their contract to a trust name on your answer, or if you're the plaintiff, then it's going to be in that trust name for your trust. Okay, yeah, we are. But listen, we're talking about your personal trust. We're not talking about the SSDQ, the public trust. Let's talk about your trust right now. Because now, remember I said equity is about your assets, right? Because these assets are now under the public trust, right? But they convert that into admiralty maritime jurisdiction. Your assets, like your loan applications and all of that, is all in that public trust. And they're controlling it. Right? They're controlling it. It's something you don't even see at all. They're controlling it. Now we're talking about your own trust, your own private trust. You have to collapse that public trust and move your assets to your trust on your Schedule A. Right? So your house contract, your car contract, these are things that you have to, your real property lot block number, these are things that you have to move on your Schedule A of your trust. You have to move that. You have to assign it there. Now you have your asset under your private trust and you are the trustee for that trust. We're not talking about beneficiary or anything like that right now. So you're the trustee for that trust. Now when you go into at the top, and let's say you have a provision in your pleading saying trust ownership, and you let the court know with the, the subject matter at hand, let's say if it's a mortgage contract at hand, you let the court know that the trust owns that, not the mortgage, the trust owns the real property, lot block number. If you assign that mortgage over to your Schedule A of your trust, then the trust owns that mortgage too. Now we got a provision in the pleading that added with the rest of the pleading that says ownership, trust ownership. Now because the trust owns everything and you have a well-pleaded case, in this case, now the judge have to see, okay, this is equity jurisdiction because the style name is not in the all cap name. The style name represents a trust. There's a trustee that's going to be your name, whoever that trustee is, representing that trust. So now this is a legal status that got to be corrected. That means you'll no longer be under the pro se model anymore. Now you be on the common law sui juris, right? So that's where you want to be, common law sui juris. So you're not under that pro se model anymore. So there's your legal style name with the trust at the end for whatever your trust name is, because you're representing that trust. And you did your well played out case, but when you plead your case out, when you draft it up, in other words, you got to keep equity in your head. And so why you got to keep equity as you drafting it up is because the judge have to determine what jurisdiction based on the nature of your draft. Sir, it's common law once you invoke it. You say there's no common law court, but you never invoked common law. Don't go by what you've heard. Don't go by what you've read. Go by what you know. Go by your experience. Do not go by what you read. Historically, people have heard, there's no this, there's no that. There's that. But who's benefiting from there's no you to believe that. As long as there is the Constitution promulgated, you have common law courts. Once you invoke it, you have to invoke it. And I see that in the pleading that we're in right now. It's been invoked. So you can't tell me there's no common law courts. You have to invoke that common law jurisdiction. As long as you have judges with oaths of office, they are under Article 3 of the Constitution that gives them the jurisdiction of law and equity, which is common law. So how are you going to say there's no common law courts when you got judges with an oath of office, if they really have an oath of office, or oath to support the Constitution? We're talking about judges that's going to do the right thing. So how are you going to say that? I'll tell you what I'm going to do with you. Because I don't know what you in here for. You're not paying attention to what I'm saying, you need to go. Yeah, we get it. But once you invoke, hello, somebody was talking about the chirp in the background. That person just blocked. If you come in here to pay attention to what's going on in the background and going on with the sounds, you said you block Chris? Correct, right? Who is Chris? I'm going to let you be the moderator. Hold on. Let me get you in here as a moderator. And you can start blocking folks. Are you a moderator? Yeah, you're a moderator. Go ahead and start blocking. You can block folks. Well, you know. I did. Yeah, you are a moderator. I put you as a moderator. You're a moderator. So, just type in their name and just go to block. I mean, just hit their profile and hit block. You can block folks, but only the ones that's not relating to us, okay? Other folks that probably been in here for a while, just hold tight on them. Thank you, Queen. So we shifted the jurisdiction. Okay, so now the judge have to see. Let me tell you this. The position that we're in is because you have the possession. Okay, you blocked them. Okay, because you have the possession. Now don't go on a block spree. Let me know who you want to block before you block them, so I can oh wait a minute, we might misinterpret somebody. Just type in their name and just let me know who you want to block before you block them, okay? Because we might end up blocking the wrong people. Brittany, what was funny? He's the only one. I'm sorry. We don't. Right, the block's free. We don't want to block the wrong people. I have to go back and think. I'm like, wait, hold on, wait. Y'all heard me? Like I'm gonna get ready to go to an auction, or I'm at an auction or something. Wait a minute, don't want to block this spree. Don't want to block it spree. We might be blocking a smart okay. We don't want to block smart okay. No. Just let me know. Do you want to block? Block party, right? With no music. So let's go. Let's get back to it. All right, multi-billion. All right. So we shifting the jurisdiction, right? Right. Let's shift the jurisdiction. So we're going to grab this maritime jurisdiction, which is the legal name. Remember that. Maritime jurisdiction, the legal status name on their contracts, right? So we're going to grab that legal status name. We're going to put it in our trust. All right? And now we perfected the name. And how do you perfect the name? UCC 1 financing statement. With that all-cap name as your debtor and you a secured party. UCC 1 financing statement, you can add that bad boy to your Schedule A of your trust. This is how we blocking that maritime jurisdiction. So capture the name through the UCC 1 financing statement. So get yourself in position in terms of the evidence now. Okay? Now the judge going to see you own Your trust own the asset. You're the trustee. You have to represent the trust, protect the trust on the behalf of the beneficiary. And on top of that, also, you're a secure party of record of that all cap name at the same time, which means they don't have maritime jurisdiction anymore. It was just collapsed because you shifted the equity. You shifted the maritime into equity. You're right. I can have a UCC. Smart. Okay. Yeah. Okay. I hope everybody got the UCC. Now you shifting that jurisdiction, right? So because you have the UCC1 financing statement, now you have the trust, and you have your assets in your trust, and the subject matter is whatever it is, the car repossession, the foreclosure, whatever that subject matter is, that asset is named in your trust, so the trust owns that. So nobody can come after the trust asset because the trustee, I hope is you, is in the position of your own trust, right? Is in a position to represent the trust on the behalf of the beneficiary. Now the courts have to look at equitable jurisdiction under Article 3 of the Constitution. Because now you've given rise to Article 3 of Section 2 of the Constitution. Trust rights, absolutely. Now you also can use common law grounds, which means you can use the violations, you can use all the violations. If the creditor violates you, violate your assets, let's say that. No, it doesn't matter. It's the best way you heard to explain. No, it doesn't matter. Doesn't matter whatsoever. All you have to do is express the trust. If you don't have to put trust certificate on a docket as evidence or anything like that. You can write an affidavit of express trust or what have you, and you can type in that subject matter in that affidavit of trust. You can just, whatever you have to do, you just declaring it under penalty and perjury. Just type in that subject matter. That subject matter, that house about to be foreclosed, type in that real property lot block number on the affidavit of trust and have it notarized. That's your trust property, okay? That's your trust property. So now it's equity. So it invokes equity jurisdiction. Why do it invoke equity jurisdiction? It invoke equity jurisdiction because you have the style name as the trustee. And because you have the style name as the trustee, you also have expressed that your trust owns the asset in your pleading. Now the judge have to do what? And then you still have the possession in your possession at the time. So that also make it equitable, meaning the judge have to make sure that you maintain the what? The status quo. So status quo means maintain the possession that you have in your trust. That means somebody can't come and take the possession that your trust owns. A document is, you know what? I do not have classes explaining documents. I sure don't, but I have a whole lot of documents. But I do not have document class. I said I wasn't here to promote no class. It wasn't me. I didn't say it. She said it. All right? So if I have to do a document class, then we can just do a document class. All right? But I'm not doing that no time soon. Not right now. So, because I have to gather them all together. Let's talk about trust right now. Let's talk about the equity jurisdiction. We can have that type of document class. We can do that one. We can do a UCC document. I'm just saying it wasn't me. It wasn't me. If y'all invoking me to do it, we can do that. If y'all ready to do that, I can set that up. I'm going to put a video out, okay? I'm going to put a video out on the profile to let y'all know the date. And y'all just go back and see if I put the video out. I don't know when right now. And it'll probably be like a 2-hour one. That's it. In a one-time class, for that week or for that month. That's not something I'm just going to do continuously. Okay, we can put one. I'm going to put it up. You couldn't get in the last time? Somebody said tap the screen. I said I was going to get out here about 3:30. So listen, I know y'all want to come up, but let's still shift the jurisdiction. Now, so y'all have your pen and paper. Style name have to end with trust. Style name have to end. Is my way of explaining? Okay, I appreciate you. Style name Yes, it deals with, yes, absolutely. Anything dealing with trust deals with the equitable jurisdiction. But it have to be yours. Don't count on no indentured trustees from a dealership or from a mortgage company. Whatever y'all find out here on the net, do not. That's not it for you. It have to be yours because their Schedule A of their trust, that's their asset, and your name is on it. Your name is on that asset. Why? Because it's a legal status name on that asset, and that legal status name is controlled by what? It's controlled by what? It's controlled by the United States. So that is their asset right now. But you can collapse it by bringing that bad boy back into your private trust and assign it to your Schedule A. You can assign it to your Schedule A. So let's talk about your trust. Because when you're in court, it don't even matter. Just express it on an affidavit. It's not even something that you have to give to the court. Miss Trina, it doesn't matter. Irrevocable, irrevocable. It's a trust. You want the word trust at the end of the name to invoke equitable jurisdiction. You really don't have to because you're an authorized representative of the trust already, you know. But it's important to have it, period. You know, doing transactions, but not for pleadings, not for court cases, because you're a trustee acting as the authorized representative. Give what to? No. Let's say you're in a court case. You have all these documents. You have your trust. You have your trust affidavit. You have your UCC1, and you can use your UCC1 showing that you have perfected that all cap name that they're trying to use under the maritime jurisdiction. So you can use that. But if you want to use power of attorney, that's power of attorney over the UCC over the all cap name, but that's during transactions, but not court proceeding. If you just want to show the court proceeding, the court say, hey, I do have POA and I perfected that all cap name, that's extra layer of protection. You can do that. So absolutely you can use it that way. So it's so many documents you can use, but you got to know how to use those documents. And you have to determine how you want to use those documents yourself. Pursuing, let's get to it. When you draft up your pleading, because you know you have the assets in your possession tangibly, that is equity. Your mind, when you draft up, have to say, I want to keep my possessions. As you draft it up, when you look at statutes that would support you. You said, what about the probate if a will in court, but trying to get I can't get the rest of what you're saying, what you're asking me. If y'all don't have no assets in your Schedule A, including a will, it's going to be hard for you to control it. It's going to be hard for you to control it. Everything, all your contract agreements have to be on your Schedule A of your trust. So you can control it. You're the authorized representative of that trust or the all cap name, you have to control it. That's the only way. If it's somewhere else and it's not labeled in your trust, it's going to be hard for you to control that thing. I don't want no Schedule A. It does fall under trust, but still your assets though. It's your assets. The schedule, that's an asset you're still protecting. Whether you fund it, whether it funds it or not, you want to protect that trust, your assets. Right now, we're not talking about monetary stuff right now. You can, but we're not talking about that. We're on keeping the status quo. So again, when you're drafting up something, as a defendant, in no way I'll be a damn defendant. Because you can do that now. Absolutely. Absolutely. So when I'm talking about opening up a trust and doing your UCC, that's what you're asking. What part are you asking, Queenie? Well, y'all leaving me off at. If you draft up your trust, you're pleading. Think about if you draft up your pleading. Think about keeping the status quo, aka keeping your possession. And the only way you can keep your possession if you know it's already assigned to your trust. If it's assigned to your trust, you know you're going to express that in your pleading. If you express that in the pleading, you already know you drafting up the nature of the case. And when you drafting up that nature of the case, and the judge get it, the judge already see this This is not amity maritime. This is under law and equity under the Constitution. Now the judge see what jurisdiction you just gave him. In other words, y'all, we control the jurisdiction based on the cases that we draft up, based on the cases, yeah, we can do that now, absolutely, based on the cases that we present to the court. So if you want to know what jurisdiction the court have, it is up to you. You make that determination, and when the judge see that case, then the judge got to determine that jurisdiction based on how you draft that case. So what is your style name? I just talked about equity. Trust is the equity. All your assets is the equity. You want to be in an equitable jurisdiction. Equity is about contract, fairness of the contract, keeping your possession, having possession. How you going to be found guilty? Are we talking about guilty on what? We talking about crimes? We talking about assets. Come on now. We talking about asset protection. I'm not talking about criminal cases at this point. Now, there we go. Gypsy Rose. I'm talking about 7 by. A pleading is, oh my God. A pleading is a lawsuit. I don't know no other way. I don't know no other way to explain what's a pleading. It's a lawsuit. If you ever drafted up a pleading, it's your verbiage, is what you're saying. No, don't block. Who you gonna block? No, don't block. Who y'all blocking? No, a pleading is a lawsuit. Everybody should know what a pleading is. I mean, how do you explain a pleading? So if the property have repossessed and foreclosed, then you got to go after them on the monetary side. I'm glad you brought it up. Thank you, Smart, okay? It's a lawsuit. I'm like, what's another way to explain? I was going to paint a picture. That's why y'all see me pause. That will have to be in your trust. That will have to be in your trust. It's in probate. The court's making a decision. Okay, just tell me who y'all trying to block, though, okay? All y'all got to do is type the name. Smart, okay, say Google court rules for pleading. Thank you, Smart, okay. Because the rest of the people say they want to learn, okay? They don't want no, they say it's too many distractions. Let me y'all hold back for a little bit, okay? You got people in here writing, they taking notes. They sitting quietly. They just saying, wait, hold on now. She's telling us some stuff, and y'all keep distracting her. So, where did we leave off at? I'm glad you know. Where did we leave off at? Structuring your pleadings, right? So, who determined it? So, style name? Style name is with trust. You expressing the trust ownership in your pleadings, along with the rest of your pleading, invoking equity court, right? This will invoke the equitable jurisdiction. Oh, repossession. So this is the purpose of that, about the repossession and foreclosure. When you invoke these, once you lost it, you have to get them to restore the status quo back. So this is what we're talking about, the status quo. Oh, how you do that? Turn off the comments. Let me see. Let me see. Well, I don't know how to do that yet. So when you are in the equity jurisdiction, when you invoke that, your whole pleading is about maintaining the status quo. That means maintain the house, maintain the car until the matter is adjudicated under the law of equity pursuant to Article 3 of the Constitution, Section 2. But when you have already lost that, when you lost your house, you lost your cars, or whatever you lost, that's monetary. Now you have to go back after monetary damages, money, and all that. Equity has nothing to do with monetary. Equity has something to do with just possession. possessions, right? It's non-monetary. It's for you to keep your possession, keep your freedom. This is what equity jurisdiction does for you, okay? So that's equity. Now, if you have lost those things, of course, one thing I just said, you can go after monetary damages, but the other one, bringing up equity, Monarch. I'm trying to bring up equity so people can understand. I want them, but they keep asking questions. I'm trying to get to it. I'm trying to get to the finish line. Some type of finish line. So hold tight. If y'all let me get to it, then y'all can get the whole picture. Be like, okay, this is where we're going. On what? See, stuff like this. On statute, what? Say it. Just say it. Oh, you said just say it? Thank you, A&P. I'm trying. Y'all running me raggedy today. It sounds so good. Oh, what about this? What about that? Hold tight. It's 3:29. Go. Okay, I'm going. So with that, you want to maintain the status quo. Thank you. I appreciate you, AP. You want to maintain the status quo by invoking equitable jurisdiction. And that's with your trust name and your trust. Okay. All right, got you. So with that being said, if you lose these possessions, once you lose these possessions, you can go back under your equitable jurisdiction and ask the judge to return the possessions back to you, okay? Under the equitable jurisdiction. Why? Because it was in trust, if it was in trust, or now do you have the contract in trust, or because you didn't have a contract, or because they didn't have perfected security interest, because it wasn't authenticated. I mean, in so many ways, and when you got to find out how that contract was entailed, because number one, they don't never have security interest at all, period. That's how you can return the status quo, meaning return the possession back to you. But again, you have to be in an equitable position for that to happen, okay? Remember, style name had to end with trust for whatever your trust name, because it shows you as a trustee, authorized representative for your trust. And then your heading, whatever that heading is, well, you want to make sure you mention something about equity. Okay, then when you start drafting up that pleading, okay, the nature of the case. So when the judge see the nature of the case is dealing with trust, the nature of the case is dealing with you having your possession, dealing with you keeping your possession, that's when the judge knows this is arising under Article 3, Section 2 of the Constitution. Now the judge see this is law and equity. Now the judge know he have to invoke constitutional grounds. Absolutely. To keep the possession, Arbit, absolutely. Yes, absolutely you can. Absolutely. That's what's happening right now in real time. This is real life stuff. I'm telling y'all, this is why I brought this message out today, because this is real life events that's happening right now that I see in the pleading and the answer from attorneys right now. In this pleading I'm seeing now equity jurisdiction is invoked, right? It has been invoked, but the way the opposing attorney is doing is trying to use the copyright name of this individual, which the copyright name is not the one that brought the claim. And the copyright name is the all-cap name. So the all-cap name is not brought the claim. It's the trustee who brought the claim, if y'all follow me, okay? It's the trustee who brought the claim. So what I see this attorney was doing, what I see the attorney, okay, so listen, it's his name and in with trustee and for his trust. This is what I'm seeing. So the answer is in, so the attorney finally answered back, and when the attorney answered back, yes, the trustee is bringing the claim 7 miles for the trust. The trustee is bringing a claim. So as I read the pleading that they answer, and the first thing they're going to do is try to do a Rule 12b-6. And a Rule 12b-6 is a dismissal for failure to state a claim, okay? And all attorneys, when they first answer, every attorney goes to Rule 12b-6. Y'all write that down. They go to Rule 12b-6 in support of Rule 56. Write that down, Rule 12b-6, and it's 332. Every attorney runs to Rule 12b-6 to try to get your case dismissed on failure to state a claim. All the time, right? They always do it. So in this particular instance, since the trustee brought the claim on the behalf of the trust, the opposing attorney said that all cap name failed to state a claim without saying that the trustee failed to state a claim. So the attorney did not use the style name in the body of the complaint in his answer and said that natural person failed to state a claim. What he went after is a derivative of the all cap name and said that all cap name derivative failed to state a claim. So, but guess what? That all cap name derivative did not make the claim, did not bring the claim, so he's right in part. Yes, it failed to state a claim because he didn't bring the claim. The trustee did. Y'all follow me now? Are you following me? Type in F if you follow me. So that's the answer that will go back. Yeah, you're right in part. You're right. This person did not bring, did fail to state a claim because he didn't bring the claim. It was the trustee who brought the claim. So you're right in part, but it's frivolous now. And you failed to omit who brought the claim. And you see the style name because you responded in your own pleading and you typed in the style name so you know who brought the claim. So why would you mislead the court and say this person without the name trust at the end failed to state the claim? No, you're actually a trustee in your own trust. Remember, this is about your own trust. It's about your own trust. Get out of the public trust mindset. You know, the execute trust. Get out of that because you don't control it. You don't control it. You don't even control it as a beneficiary. I hate sad to say. You don't control it as a trustee. You don't control it as a beneficiary. You just completely out of control. But when you have your own private trust, then you control it. You want to be the trustee. You want to be the beneficiary. No, not at all. No, they don't. It doesn't. No. So again, we talking about the private trust, your trust. So that's one aspect. So that's that. So right now, what the attorney is doing in this case, yeah. In fact, that's a disqualification, life coach. You can move to disqualify that attorney, move to sanction that attorney, these type of motions, right? So we can do that, and that's what's going to be happening. So another thing I caught what the attorney was doing. So what the attorney was doing in that case was trying to change the trustee legal status because that's critical. That style name is very critical because that also invokes the type of jurisdiction. So the attorney is trying to change the nature of the pleading by his answer, hoping that the trustee do not proceeding. Oh no, it's not. I've done it. It's at the top right here. I've done it. No, it's not. What you talking about? It's hard. No, I've disqualified attorneys, absolute, and judges. And it's bad for them. It's detrimental for them. When you disqualify an attorney, then all they're going to do is get another person in their firm. You keep disqualifying them. That's over with for them. That's not hard at all. That's the most simplest task. So that's that. So remember, the attorney was trying to do what? You got to catch their angle. The attorney was trying to change the legal status. But that name that the attorney said failed to state the claim is not a party to the claim. Not a party to that petition. So that name don't even exist. So where did you reach for that at? And that name that he put in there is a copywritten name. So now he's going to get a bill and an invoice in that answer. Because he used a copywritten name, trademark name, and to try to change and undermine the pleading and the legal status of this case. That's what the attorney was trying to do. So the other thing about it, right? Mad TV? So, right, exactly. So the other thing he was trying to do, he used evidence in the all-cap name from another court proceeding from a couple of years ago. So he used that and used as evidence, but it's an all-cap name, and literally said to support that evidence, that order from a previous judge in the all-cap name, and literally said in parentheses, this is an in rem proceeding. Like, he so disgusted right now. He had to literally say to this judge in the court, hey, hold on now. I know this said trustee at the end of this name. But remember 2 years ago when this judge made the order, it was an interim proceeding. So let's go back to that interim proceeding type of thing. Yeah, they're not going to respond. But he's going to get a bill on this one. Yeah, they're not going to respond. But, so this is what the attorney is trying to do. The attorney is trying to shift the nature of the claim from equity, I just need y'all to follow me, from equity jurisdiction to a maritime jurisdiction by incorporating the all-cap name that's already copywritten. Little beknownst to him, he should have known. So already copywritten, he's trying to use that to shift and undermine the pleading into a maritime pleading. He wants the judge to make a decision on maritime because they don't have no jurisdiction. The attorney don't have nothing because why? The trust owns the asset. The trust owns the property. And that means the trustee still have to maintain the status quo on behalf of the beneficiary, meaning keeping the property. So that means he knows the judge, because of all the facts and the evidence and the way the petition is drafted up, the judge has to make an equitable decision under the common law, under the Constitution. So yes, that individual name that he put in the pleading that don't exist in the pleading did fail to state the claim because that name never brought the claim. Absolutely. And you see that. Right, they don't have jurisdiction. Even if you have a trust, that's foreign to them. They do not have jurisdiction. So, everybody follow me on this so far? I just gave you that a little bit. So, what position y'all have to be in? Trustee position, on behalf of your trust, legal status, and you're not in pro se. You're not a pro se. You're now series juries. Everybody see? Y'all get it? Good stuff. Let me give y'all. Come on, Smart OK in 7 miles. I'm gonna get out of here. Let y'all have y'all little comments, and I'm out. I gotta go.
Hey, Doc.
Y'all so what's up, 7 miles? You wanna make a comment?
Yeah, thank you so much for the live, man. That was just a very transparent explanation of what's going on in court.
Awesome. You're so welcome. Smart OK. Y'all want to say something? I'm not gonna make it long in here. Y'all just gonna make a comment. I'm out of here.
Nah. I took my notes.
I got it.
I just promised to bring you up.
I got it on record too.
Y'all don't want to talk?
You can't hear me?
Smart OK, you speaking?
Yeah, I'm talking.
Okay, I can hear you now. Go ahead. I'm sorry.
Oh yeah, I was just saying thank you because the explanation of what's going on and how to style the name that provided a lot of clarity for me too. I was taking notes and I recorded the live.
Good deal. So that helps out a whole lot. Anybody else? 7 miles? What's your take back? Your feedback?
No, I came in late, but I got what you were saying. Yeah, I came in a little late, but I got it.
Okay. I know you're going to have it. Okay, let's see. Somebody else want to say something before I get out of here?